You're packing up your toolbox in the parking lot after quitting your job at the local HVAC company, and your boss hands you a manila envelope. Inside is a threatening letter from a lawyer saying you can't work for any other heating and cooling business within 50 miles for the next 2 years. You've got a mortgage and a truck payment. You're wondering if you just lost your right to earn a living. That piece of paper is called a non-compete, which is a contract clause where your employer makes you agree not to work for their competitors after you leave. It's completely terrifying to get one of these letters at 11 at night. But before you start applying for jobs at the grocery store, you need to know that most of these documents are absolute garbage. I am going to rank the top 4 reasons your non-compete is probably unenforceable, which is a legal term meaning a judge will refuse to enforce it. We'll start with the absolute worst mistakes a company can make and count down to the best ones. Keep in mind, this is education, not legal advice, because contract laws vary wildly by state. Starting at number 4 on our countdown, the employer put 0 geographical limit on the agreement. Let's say you're a diesel mechanic and you signed a paper saying you won't work for another truck repair shop anywhere in the United States. A judge will look at that and laugh. A non-compete has to have a reasonable geographic scope, which is a legal term meaning the physical area the restriction covers. If your employer only operates in your specific city, they can't ban you from working across the entire country. A judge will require the geographical limit to be strictly tied to where the employer actually does business. So if you're a carpenter in Ohio, your boss can't stop you from taking a job framing houses in Florida. But remember, what counts as reasonable changes depending on where you live. As an example, what seems reasonable in a massive state like Texas might be completely different in a tiny state like Rhode Island. Every state has its own specific rules for measuring distance. Moving down the ladder to number 3, the company kept you in the dark about their actual legitimate business interest. You'll hear lawyers use that phrase, legitimate business interest. It means a valid reason a company needs protection, like keeping a competitor from stealing their hard-earned customers or using their top-secret methods. Let's say you install cable for a living. Your employer has a legitimate interest in protecting their list of clients. But if you're just digging trenches and they hand you a non-compete, it doesn't make sense. You don't have access to the customer lists, and you don't know the pricing models. If you don't possess actual trade secrets, which are confidential pieces of business information that give a company its competitive edge, the employer can't use a non-compete to trap you. They're only allowed to protect their actual business assets. If you're just doing general manual labor, they can't restrict you from doing general manual labor somewhere else. Climbing down to number 2, they forced you to sign it after you already started working. This is a massive mistake companies make all the time. In contract law, both sides have to give something up to make a deal valid. This is called consideration, which is a legal term meaning something of value that's exchanged to make a contract legally binding. If you sign a non-compete before your first day, the consideration is the job offer itself. But if you've already been working at the warehouse for 6 months and your boss slides a non-compete across the desk and says sign this or you're fired, they have a huge problem. In many states, continuing to keep your job isn't enough consideration to force you into a brand new restriction. Some states allow this, but many others will instantly throw the entire contract out the window because the employer didn't give you a raise, a bonus, or some other new benefit in exchange for taking away your right to quit and work nearby. The timing of your signature matters immensely. And finally, arriving at number 1 on the countdown, the absolute biggest reason a non-compete fails is that it violates basic public policy. Public policy is a legal concept, meaning the courts won't enforce agreements that harm the general public or violate established state laws. Let's say you're a nurse at a local clinic. You quit, and they try to enforce a non-compete against you. In a massive number of states, courts flat out refuse to enforce non-competes against doctors, nurses, and certain other medical professionals. Why? Because the public needs health care. If a judge enforces a rule that stops you from treating sick patients, the community suffers. But public policy goes further than just medicine. Remember the Federal Trade Commission? They're the government agency that regulates business practices. They recently proposed a massive rule to ban non-competes nationwide. While the exact details of that federal rule are still being fought over in the courts, it shows exactly where public policy is heading. But you don't even need a federal rule because several states have decided non-competes are entirely against their public policy. As an example, in California, non-competes are almost completely illegal. North Dakota and Oklahoma are the exact same way. If you live in a state that says these contracts are against public policy, it doesn't matter what you signed, the paper is worthless. So, if your employer makes one of these 4 massive mistakes, what happens next? Let's say you get a cease and desist letter, which is a formal demand letter from a lawyer telling you to stop working or face a lawsuit. You read the letter, and you realize the geographical restriction is completely unreasonable. Or you realize they never gave you any new consideration when they forced you to sign it. This is exactly when you need to get a local employment lawyer. A good lawyer will write a response letter explaining why the contract is unenforceable. Usually, once an employer realizes their paperwork is full of holes, they back down. They know they can't win in court. But we've to talk about a dangerous trap here. If your employer actually sues you, they'll ask the judge for something called a preliminary injunction. A preliminary injunction is a court order that forces you to stop working immediately while the lawsuit is still going on. The lawsuit might take 2 years to finish. If the judge grants that injunction, you can't work in your trade for 2 years. Even if you eventually win the case, you still lose because you've been out of an income the entire time. This is why you never just ignore a legal threat. You have to take it seriously and get a lawyer to dismantle it before it gets to a judge. Also, some agreements aren't actually non-competes. They're called non-solicit agreements. Non-solicit is a legal term, meaning you agree not to actively ask your former customers to leave your old boss and come with you. Courts enforce non-solicit agreements much more strictly than non-competes because you can still work for a competitor, you just can't steal the client list. But here's the catch. If a non-solicit agreement is written so broadly that it completely stops you from working at all, a judge will treat it exactly like an illegal non-compete. This is why you need a professional to read the exact words on your specific piece of paper. What is the most ridiculous restriction a boss ever tried to put in your employment contract? Tell me down in the comments. If this breakdown gave you the upper hand against a scary piece of paper, share this video with a coworker who is sweating over a letter from a company lawyer right now. Make sure you subscribe to Scribble Law so you always know the actual rules of the game before an employer tries to use the system to block your paycheck.